Welcome to Criminal Justice 101 Perspective and Policies class. I'm Unique Lamia, and in this module, we will be going over consent searches, what qualifies the criteria for a consent search, and involuntary consent searches. So as we discussed in a previous video, the Fourth Amendment of the United States protects unreasonable searches and seizures. And generally, when a search and a seizure is conducted by law enforcement officers, a warrant is needed. A warrant essentially is where an officer, they go to a judge, a magistrate, or another individual who has the legal authority to issue a warrant, and they write an affidavit, the law enforcement officer, essentially noting where they want to search, when they want to search, why they want to search, so what probable cause do they have to suspect that this individual may have contraband or have committed criminal activity that is grounds for this search to occur. In this affidavit, the officers, they submit it to the judge, the magistrate. It is generally signed, and then once it's signed, the officers have perhaps a few days to a week to conduct this search. However, when consent searches occur, these searches generally occur without a warrant, and they occur when a person voluntarily waives their Fourth Amendment rights and allows law enforcement officers to search their body, premises, or belongings. These consent searches are generally faster than a warrant because you don't need a warrant, so they're faster, and this could cause the officer to abuse the defendant's Fourth Amendment right. Because we have to remember, when a consent search happens, let's say I'm in my home and an officer knocks in my door. They come, they knock on the door, and they're like, hey, can I search your house? And if I say, yes, you can search my house, or if I open the door for them and let them walk in without saying anything, that is essentially me giving consent for the officers to search my home. And that is a very broad scope. No parameters are laid down on where the officer can search, so they can abuse my Fourth Amendment right, search my whole house, probably take items they weren't allowed to take. So this is why when you engage in consent searches, if you decide to allow an officer to search your home or search your body or search your personal item without a warrant, you can lay parameters. And when I say this, you can define the scope in which the consent search can occur. So if an officer comes to your home and they're like, hey, can I search your home? And they don't have a warrant, but you allow this consent search to occur, you can say, yes, you can search my home. However, I only consent to you searching the kitchen, my garage, and my bedroom, and you can only search for 1 hour. That is you laying the parameters of the consent search. That is you laying the scope of the consent search. Obviously, officers, they can go outside of that scope because once they're in the unit, they have the authority, so they may still abuse their power sometimes. Some may not. But when you lay these parameters, it protects you. So later on, perhaps if you want to bring a lawsuit or something, you have grounds to do that if you want to get evidence suppressed or evidence dismissed in court. So let's go over some criteria to determine if a consent search is voluntary. Courts look at the totality of circumstances. This essentially means courts are looking at the force, threat of force, or other threats that were potentially present. They are looking at the submission to a fraudulent or mistaken claim of authority so that the officer lie about the circumstances when they ask you to conduct this consent search. They are looking at the misrepresentation or deception by the officer, and they are looking at the arrest or detention of a suspect. So if you were arrested and then an officer asks you to engage in this consent search, this could have been involuntary consent was present. The suspect's knowledge of their rights to refuse consent is also looked at. A person's consent to search based on false impressions created by a law enforcement officer is not voluntary. This is essentially saying, as I said earlier, if an officer creates a fake scenario saying, hey, your brother is detained or your cousin is detained and we need to search this unit because they gave consent when that is not true, that and you give consent to search, that is not a voluntary search because the officers created false impressions and a fake scenario to have occurred. Who are arrested or detained, they are more likely to be coerced due to the arrest, and they have a lack of free will to leave. And when you're arrested and you have a lack of free will to leave, generally voluntary searches. It's very hard to prove that a voluntary search was present. So we have something known as coercive action. Coercive action generally leads to involuntary searches. Things are like handcuffing, as I said, a display of weapons if the person is incarcerated. In the courts, it has found that if a person gives consent, however, if like they hesitate to give this consent, the consent may not be voluntary. I mentioned it briefly earlier that nonverbal cues can be indicators of voluntary consent. So once again, let's say an officer pulls you over on the side of a road and they pull you over for perhaps a speeding ticket. They give you the speeding ticket. They go through like the traditional traffic stop regulation. So they check your ID, they ask you some questions, you get your speeding ticket, right? And then at the end of the traffic stop, the officers ask you to open your trunk because they want to search your trunk. If you don't say anything, but if you comply with the officer's instructions by opening your trunk, you voluntarily consented to that search to occur. If you verbalize, yes, you can search my trunk, you voluntarily consented for that search to occur. So nonverbal and verbal cues are very important. So when we're looking at who has the authority to give consent to search your home, there's a few different people. So first we have common authority. Common authority is just a person living in the property but does not own it. So this common authority can perhaps be maybe if you have a friend, a boyfriend, a girlfriend living in that apartment, if they're not paying for it, but if they're living there for like a substantial amount of time or staying there with you, they have the authority to give consent for an officer to search your home for you. So if an officer comes to their home and you're not present, even though like you own the property or you're paying the rent for that property, but your friend there or your significant other there who is in that unit, if they give voluntary consent, you gave voluntary consent because in that moment they were acting as your spokesperson. We also have actual authority, and as the name suggests, you as the owner or you as the individual who is paying rent for that property, you have the actual and legal authority to give officers consent and voluntary consent to access and search your home. There's also apparent common authority, and this is saying a warrantless entry and search is valid when based on the consent of the third party who the police at the time of entry reasonably believe to possess common authority of the premises, but who in fact does not have such authority. So this is saying, once again, these can be your parents. Your parents may not live in your house 24/7, but if they are just visiting your house for that hour and police come to the unit, and if your parents voluntary consent, then you voluntarily consented. It can even be an employee or an employer in like your workplace setting. You do not have legal authority or legal control over your place of employment. So like your manager, your supervisor, if an officer comes to your place of work, they can request to search your property, your locker perhaps, and they can do that. However, some court cases have found that your manager can't give voluntary consent for like your work desk to be searched, since like you, when you're at work, you probably predominantly be there. So in that moment you have like authority over that area. But like I said, there is some gray area there. It should be noted that even though like voluntary consent exists, and generally a search warrant is needed to like search units or that voluntary consent, there's something known as exigent circumstances, and this is saying that the officer has probable cause to believe that someone will be harmed if they do not enter the unit right away. And officers, as long as they have this probable cause, they do not need voluntary consent, they do not need a search warrant, they can enter the unit because they are doing this to protect someone's life essentially. So other interesting examples of like how you or your employer can give voluntary consent to search a unit to law enforcement officers. If you are a student who lives on campus in like housing and residence life, when you sign your housing agreement, generally you give voluntary consent for like the housing supervisor to give law enforcement officers consent to search your unit for you in certain circumstances. Also, when you rent a hotel room, like the hotel staff members, the hotel managers, they can't give voluntary consent for all law enforcement officers to search your hotel rooms as long as like you paid for that unit and you have your personal items in that unit, because when you pay for that room for that one night, 1 week in a hotel, you become like the person who has the actual authority in that unit. So overall, when you're looking at consent searches, involuntary consent searches in the field of criminal justice, if you are pulled over by a law enforcement officer for a traffic stop and they ask you, hey, can I conduct a search of your car? If you don't want the search to be conducted, you could just say respectfully, no, I do not consent to this search to occur. And once you do that respectfully, the officer may listen to you, they may not listen to you. However, if you later on want to like take action against the officer if they violated your rights, you have reasonable grounds to do that if you verbalize that information. In my opinion, guys, this is just my opinion, the best way to proceed with a search with law enforcement officers is generally under the scope of a search warrant. I say that because a search warrant, it sets specific parameters on when the search is going to occur, how the search should be conducted, and it essentially gives officers a set of guidelines on how to act to protect the officers and to protect yourself. However, if you do want to consent to a voluntary scope or a voluntary search, you should set parameters saying, okay, you can search this room, this room, this room for this duration of time. So hopefully you enjoyed this video. As always, it's a pleasure making these criminal justice videos for you guys. So leave my question for you guys. Were you surprised to learn about the difference between voluntary and involuntary consent searches?